So today I want to introduce Jonathan Kaplan. He is a lawyer specializing in IP issues. I met him at We Robot, the robotics policy and legal conference, and he needs to update his equipment. And so he's going to talk about some interesting IP issues around startups, and maybe try and get us to learn something that we need to know about IP.
My pleasure. Well, thank you very much for the invite, and I'm delighted that so many people have come this morning. So I guess let me tell you a little bit about me, so I've been an IP attorney, basically a patent attorney for the past 23 years. And before that, I was not too dissimilar from many of you probably. I did robotics research in the mid-1980s, that was my main interest in terms of a research area. I worked at a robotic systems research group at Bell Laboratories, and I did computer vision work at MIT, and then for a variety of reasons, I decided to check out. I became aware of IP, and I thought it might be a very interesting career, and went to law school. And so I guess the rest is history. Most of my career, I've done a lot of work with patenting of integrated circuits, related to integrated circuits, either the circuits themselves or tools for designing the chips. There hasn't been all that much opportunity for me to do IP that's directly related to robotics until I would say the last 4 years or so. So it's a very exciting time for me because, like 30 years later, I'm sort of coming back full circle to being able to work in the technical area that personally interests me the most. So that's a lot of fun. I'm very happy to be here. And so let's see. So I do a lot of work with startup companies. I enjoy working for startup companies probably more than any other kind of client. So I'm hopefully going to give you information that would be good for any company, but I'm going to be orienting more towards a small company, particularly a startup company, a very small company. So let's see. So so I have a standard disclaimer. So I am a lawyer, but I'm not acting as a lawyer right now. So none of you are my client. You're not getting legal advice. So, but hopefully I'll raise interesting questions, and you'll be able to interact with your attorney someday more intelligently because of what you've learned here. So first, Bill asked me to start out by just explaining what is intellectual property, because the backgrounds are not that, you don't have that much background in this area. And so basically, intellectual property it takes a work of the mind and translates it into a property right that you can own and enforce and start companies with and so forth. So, and there are 4 main types of IP. There are trade secrets, patents, copyrights, and trademarks. And it's amazing how confused many people are about these, just the basic categories. People ask me, well, can I trademark this? And what they really mean is, can I patent it? Things like that. So maybe I'll just start with the bottom of the list. So trademark is the least technically related kind of IP. It's basically a brand name or a symbol, Coca-Cola, etc. It really has nothing to do with technology, although obviously technology companies they all have their trademark, and they're very important when they reach a certain level of scale. And you should think about trademarks even when you're a startup company. You should think about that. In terms of my interest, my main interests are at the top: trade secrets and patents. and that's really what these are really the two that are of main concern to a technology startup, and particularly any startup that would come out of this lab would be a technology startup. So your basic, from an IP perspective, when you're starting a business, your first goal is to, and Bill, please feel free to jump in if you think. So your first goal is to think of a business model where you can, first of all, get a first mover advantage or an early mover advantage, and then as a result of your normal day-to-day business operations, you will generate, basically, from an IP perspective, what I would call trade secrets. So you will continue to pile up secret and valuable information. And that's what will be the workhorse of your company. That's what will drive the engine day to day. So if you look at pretty much every tech company has that model. Look at Google, for example. So, obviously probably the most successful recent company anyway. So they actually, they originally had a patent on their page ranking algorithm. But longer term, really what drove the company here and what drives them now is trade secrets. Because, they have a very substantial patent portfolio, but a lot of the value is in these under-the-cover algorithms and data by which they're able to find what you think you're looking for faster and better than any other search engine. And they have this what they call virtuous cycle in business school parlance, that the more you use it, the more data they build up, and that makes them better at doing it for others, and it's secret. So they continually get a sustainable competitive advantage over their competitors. Now, the patent is more, so the trade secret is the workhorse. The patent is more of the thoroughbred. So that's kind of like the showy, fancy, animal that comes along every now and then. And very often the first few patents that a company files are the most important because they're the basis of the company. And unfortunately, in many cases, they are the worst done patents because you have the least resources, both in terms of people hours and dollars to actually get it done. But a patent in general, it protects an application of engineering or scientific techniques. It's where you think of something and you stop and say, gee, I think this could have a lot of uses outside of just my particular business model. Maybe I should think of owning this. Or you think, gee, this is a technique that I think could be valuable for the next 5 or 10 years, maybe longer. This is a technique where, I think it's going to have a big market impact. If it works, it could capture a big market. And by a big market, I mean tens of millions of dollars a year in revenue. Because if the invention doesn't generate revenue in that range, then no one's ever going to pay to enforce it. Because the only way a patent is worth something is if somebody will pay millions of dollars to enforce it in court. Because patent litigations are very expensive. So that's sort of what I call the deep pockets dilemma of deciding whether to patent something. And then copyright, I'll just mention very briefly. So copyright is basically, the key word to think of with a copyright is the word expression. So a copyright protects the expression of an idea, your particular expression, but not the idea itself. So for example, just to make it very easy, take like a novel or story like, say Julius Caesar, right? So that particular, the way, Shakespeare might have chosen to express the idea of somebody becoming, a dictator, and then, becoming too powerful, and then being assassinated because of it. So that particular expression that he wrote, that's protected by copyright. But as I'm characterizing, the basic idea of, someone becoming a dictator and then becoming, assassinated, that is going to be expressed in many different ways. And so that would not be protected. So is this making sense? Okay, good. And I thought about it, and if you have a question, please feel free to jump in and ask me a question. And then there are three main modes by which IP is used, or by which people interact with IP. It's created, it's enforced, and then it's used or exploited. And so the I in IP is done by the inventor or the author or the creator, and then the lawyer helps make it into the P part, makes it into property that you can own. And enforcement is basically about mostly about litigation, going to court to enforce a right, and this is what most people think of when they think of a lawyer. They think of somebody in court before a judge and arguing and so forth. But that's only a very small part of what working attorneys actually do. But it's very dramatic, so it makes for great entertainment. And then in terms of exploitation, that's where you form agreements that allow the IP to be used. And since I'm at a university here, I'm going to focus on the licensing, which is done by pretty much every university has a technology transfer office. So does yours. And they write agreements. First of all, they'll help you get IP in the first place, like patents. And then if you have something that looks promising and you want to spin off a company of some kind, they will help you set up the company and set up licensing agreements so that your startup company can use the IP that you created at the university. Typically, it's what they call an exclusive license, so that only your company can use the IP. That gives you a competitive advantage over the other entrants from other areas. But almost always, if you have an exclusive license, then you're going to have to meet certain performance goals. So if you don't use the IP successfully enough, they'll have some sort of performance metrics. You obviously could lose the license. That's one of the main points that you have to be aware of. And the basically, university technology transfer has been a major issue since about 1980, which is when there was a law in the US called the Bayh-Dole Act, and that's the foundation for all of it. And that's when institutions, if they didn't have it already, they created technology licensing offices, because what this act allowed for is, as you know, most academic research is funded by the government, and this act said that even though the government paid for you to do this research, you and the university, you can acquire ownership to it. And then the idea is that would help put the information and the technology out there. And so that's what that's really what characterizes, I would say, university technology licensing. It's characterized by an emphasis on using the technology to promote public good and therefore justify the further funding of the institution. It's not really so that the institution itself can directly make huge profits off of it. The idea is, let's get the technology out there and let's show people that it's a good thing to have this university here, and basically eventually if you have enough of an ecosystem, it will come back to the university in one form or other. It will benefit the university. So let's see. And then there's actually a association called Autumn, which is specifically for university technology licensors and managers, called Autumn. Let's see. So now I'm going to, now the rest of this talk is going to focus very heavily on, basically, exclusively on patents. And so let's look at, we touched on the patent briefly, let's return to it in some more detail. So, what is a patent? Well, it's basically, it's a right to sue, basically. Fundamentally, it's not worth anything if you can't enforce it in court. It's not. And it allows you to prevent others from practicing your invention. And your invention is, now that does not, surprisingly enough, it doesn't mean that you can actually do the invention yourself, because pretty much every invention is a combination of old elements, so to speak, to some extent. I mean, pretty much everything done here at some level is using let's say the transistor was an invention, what was it, 60 years ago or something? Okay, so, if there were still a patent on the transistor, then you all could be guilty of patent infringement on the transistor regardless of what great robotic invention you come up with. So just because you have a patent doesn't mean you can actually practice it. And it doesn't necessarily mean that even if you can practice it, that you'll be able to practice it in the most commercially viable and best way. The reason for that is because if you came up with, for example, like what you might call a pioneering patent, let's say you came up with the transistor, so then there could be others who come along and look at your patent and they learn how to make a better transistor, and they could patent that improvement as long as it's what they call non-obvious over your previous invention, and that's entirely possible. So it might turn out that, maybe, you invented the bipolar transistor, and then, I'm playing a little fast and loose here with history here, but let's say someone comes along and, they invent the field effect transistor, the metal oxide transistor, and that's what becomes really valuable because that's how you make transistors for integrated circuits. And they could patent that, even though the basic bipolar, what they call the claims of the basic bipolar might cover that, but still the metal oxide semiconductor was a very clever advance within that pioneering idea of field of transistors. So, and there are two main parts of a patent. There's what's called the specification, which is the written description, and then there are the claims, which define your right to sue. So the claims are what legally define the invention, and we're going to go over each of these in more detail right now. So the basic quid pro quo of the patent system is that we're encouraging the disclosure of information that wouldn't otherwise become public because, for example, before patents became so widely used in the computer and particularly computer area in the early 1990s, computer companies, I remember this quite well from when I worked in an industry as software engineer in the 1980s. All you had was trade secret. So your whole goal in terms of software was always not only can I come up with a good business model, but is it a model that I can keep secret? And what's the best way to keep it secret? So patents do allow for more sharing of information. And in exchange for that, you obtain these, what they call exclusionary rights for a limited period of time. The basic patenting process is you start out with a patent office. In the United States, it would be the USPTO, and they provide the initial grant of the patent rights. It's basically it's basically a non-adversarial process. It's just you as the applicant arguing with the patent examiner who is selected for you by some process of the patent office, and there's no one on the other side saying, oh, I think what this applicant just said is wrong. It's not. It's just you and the examiner. So it's called an ex parte because it means just one party process. But then if you want to enforce it, then you have to go to the federal courts, and then you're going to have an adversarial process. You're going to have two parties arguing on either side of it, and the federal court review is the most thorough, and that's the one where I said that to bring a patent suit or to defend a patent suit, it's going to run into millions of dollars in terms of fees. And then this basic model of initial grant of rights through a government patent office and then a more thorough review through the court system is pretty much followed by all countries. So let's return to the two main parts of a patent. So as I said, there's a specification, which consists of written description, narrative of some kind, and also drawings. And it discloses the embodiments of the invention that you came up with. The main legal requirement for this description is that it has to be enabling, which means that if you were to hand this written description over to someone of ordinary skill in your area, whatever that means, you have to try to imagine as best you can. And presumably you're way above ordinary because you wouldn't have thought of it in the first place. But you have to think of, if you handed this description over to an ordinary person, let's say at a competing company, would the description be good enough that they could read it and then make and use the invention? Now, that doesn't mean they have to be able to make and use the product, they just have to be able to make and use the invention. And what the invention is defined by the claims part of the patent. And the claims, they're very hard for the non-lawyer to understand, but in general. But the basic idea is pretty simple. It's just a checklist of items that need to be satisfied for something that's potentially infringing. It could be a product or a process, depending upon how you write the claim, to infringe. And the basic dilemma that guides the writing of your claims is that you, as the person seeking a patent, you would like this checklist of items that need to be satisfied. You'd like it to have as few items as possible, and you'd like each item to be described as generally as possible, because that will give you what's called broader scope, because it can be satisfied by more things out there in the world in the future. So now, on the other hand, if this checklist is satisfied by anything that's in the prior art, anything that came before your invention, then the entire claim is invalid. So that's why you have to be careful. So you can't just write incredibly broad claims and be done with it. You do have to strike this balance. So does that make sense? Okay. So I'm going to give just a very simple example of a claim. So you have what's called the preamble, which basically defines the general area. So let's say, this is 120 years ago and the car has just been invented. So I'm claiming a vehicle, and then here are only two elements, 4 wheels and an engine. So then we would say, okay, so obviously, would a motorcycle infringe this claim? Well, the motorcycle has an engine, but it only has 2 wheels. So as written, this claim would not be infringed. So it's really basically as simple as that. The hard part really is understanding the technology and what the words are supposed to mean here. So let's see. So maybe if this is you have a great algorithm for planning trajectory through through an interior space, and you say using an A-star algorithm that applies Monte Carlo techniques, something like that. That's where it gets complicated. It's trying to figure out that wording, and then that wording has to be, as I mentioned before, it has to be non-obvious and novel over what's been done before, but you still want it to be broad enough so that it covers that if someone was practicing it, you would say, oh, that's unfair, they're using my invention. So this is called the independent claim, and then you have dependent claims, which basically just add on additional elements to the checklist, and it's a hierarchical structure here. So you can have, typically you have just a few independent claims, which basically start a new checklist, and then you can have, under that parent node, you can have a number of child nodes, each of which can add one or more elements to that, separately add to that checklist. And so here, we further refined it to say that it has to have 4 doors. So, obviously, a 2-door car is going to infringe this claim, our independent claim, but it's not going to infringe our dependent claim. Now, you might ask, basically, anything that would infringe one of your dependent claims will necessarily infringe the broadest independent claim. So you might ask, well, why would you even bother with dependent claims? Well, the reason is because when you're filing and even obtaining the patent in the patent office, it is the worst time to know what they call prior art is out there, because there are other people working at the same time. They may be filing patent applications. You won't know about them until years later. So you need to have fallback positions, basically. So you come up with your broadest, sort of your broadest ask. If I think this is fair, but if I got this, I'd be really happy. I think I'm entitled to it, but I'd be really happy. It may even be more scope than I really need from a commercial point of view to protect my company now. And then you would have several dependent claims where you would add further elaborations on that most broad idea, and elaborations that you think were also clever and in themselves, so that even if someone found prior art that made this broadest claim obvious, you could still succeed on one of the dependent claims, and each of those claims could stand on their own. So even though even if this is found invalid, this could still be valid because it adds another element. So I think this is a good mantra that I've come up with over the years to keep in mind when you're seeking to patent something. The patent is not the product, or it's not the project that motivated the invention. The patent is only for those specific techniques that you think were the real contribution to your area. So you may have come up with a great robot that maybe helps the elderly, and it has, maybe it's a wheelchair kind, it has 4 wheels, it's a wheelchair shape and so forth. Now maybe as a result of coming up with that, you came up with a great planning algorithm, that's fast and needs less hardware, it's cheaper hardware, it's fast but it doesn't need much hardware, or it's inexpensive hardware. And you say to yourself, yeah, that's great, but I think this could be useful in a lot of other vehicles that need to do planning. So you only need to protect that planning algorithm as applied to vehicles, let's say, and planning. You don't need to disclose all the details of the wheelchair or whatever other kind of vehicle that might have motivated you to come up with it. And so the nice thing about that is that basically any aspects of your product or project that aren't needed to support the claims, that aren't needed to make it enabling, as we talked about earlier, that somebody else could make and use the invention as claimed, you can keep it as a trade secret. You don't have to put it in the patent application. And you certainly, you don't want to put more information out there than you have to. And I'll just talk briefly about deciding when you should patent. And basically, the trade-off usually is whether to patent or to keep information as a trade secret. So usually, the question is not usually whether you can patent something, and I think particularly in this area where you're dealing with machines and so forth, there's been you might have heard about a lot of controversy about pure software patents being patentable, but here you're actually making things happen in the real world, so to speak. So the question is not whether it can be patented, but whether the patenting makes economic sense. And I've already discussed a lot of these issues, but it's good to review them as a list. So it's got to have at least a 5 to 10 year lifespan. You've got to feel it's going to be valuable for at least 5 to 10 years, hopefully longer, because typically it'll take 3 to 5 years just to get the patent in the first place. So if the idea is obsolete by the time you get your patent, what was the point? You're better off just keeping it as a trade secret. And as we mentioned before, it needs to cover a very large market to justify the millions of dollars it would cost to enforce. I mean, there are all sorts of really cool inventions, but they'll never cover markets that are worth fighting over. Those are some of the key things. And if you have a multiplicity of ideas, a lot of ideas, then you have to do a review and create some sort of a prioritized list and say, well, which ones are really the most important ones that I really need? Because as a startup, your time and your capital are always very limited, so you may have to make some hard decisions. And so trade secrets should be basically everything else should be a trade secret. That's the way your company should be structured. That's the default protection. And there's a lot of information that's very valuable to your company that just can't be patented, such as customer lists, financial records, market analysis. So all this would be trade secret information. And if somebody were to steal it from you, you could sue them for trade secret misappropriation. You also should consider trade secrecy if the invention is difficult to detect in a competitor. Then, even if you could enforce it, let's say everything else is okay, you have the money to enforce it and so forth, but if you never know if a competitor is doing it or not, well, how do you ever start the lawsuit? So, if it's really sort of an under the hood type of invention, that's something to think about. Another thing is, can you exploit the invention without it being revealed in the product or service that you're actually selling? So that's true. I don't think that'll be true so much in the robotic area, but there are all sorts of basically companies that are software as a service where you're just using the end result. Let's say a travel app that plans your trip on your trip and so forth. There could be all sorts of algorithms that are happening on the server that you could never detect from just being as a user. You just get the end result. So if that's what your invention is, then you do have the option just to keep it a trade secret. And one of the nice things about a trade secret is that as long as you were able to keep it secret, you have it indefinitely. There's no limited time on it. So the advantage of the trade secrecy, it can be almost any type of information that has of commercial value, as long as you take reasonable steps to protect it. It's very easy to obtain. You do have to take a few steps. Just go over them again. Well, this one we didn't talk about was you need to make sure that everybody has employee agreements, whether they're consultants or employees. They have to pledge to take reasonable steps. They will keep it secret, and they will take reasonable steps to keep it secret, and so forth. And it's also important that that the agreements say in the present tense that I hereby assign my IP to the company, that actually can make a difference, as opposed to, I promise to assign, which is more of a future-oriented thing. I will, when I have the IP, but this says basically, as soon as I create it, the company owns it. And you need to have agreements that place a continuing post-employment obligation to maintain the confidentiality, and the company must take reasonable steps to protect it, to keep it secret. Disadvantages, there are a lot of inventions where keeping it secret, you can't operate that way. If you're selling a robot and the invention is in the robot that you're selling, and people can figure it out from using it, or maybe they take it apart, they can figure it out pretty easily, well, then you can have a hard time maintaining it as a trade secret. Someone else can independently come up with the same thing. So if someone else comes up with it, they're perfectly entitled to use it. Also, trade secrecies generally have a tendency to, what I would say, evaporate. That a lot of it is because you're working in an industry generally with other competitors and other companies, and people move around. Information is disclosed at conferences. The whole state of the art moves forward, and gradually, generally, whatever was a trade secret at one point tends to evaporate over time. And trade secrets are very difficult to litigate. When it comes time to actually litigate them, a lot of times it's really, really hard to put your finger on what was the trade secret. So with patent, once it's been filed, long before you obtained it, could be years before you obtained it. As long as you filed it, what you're looking to get, you can talk about it publicly and you can sell it and so forth. You don't have to worry about it. That's a huge advantage with patent. If someone else comes up, independently invents it, you can still sue them for it. Still sue them for infringement, in general. And it's a very powerful form of IP. There are a lot of kinds of what they call damages you can get. There's at base is what's called reasonable royalty. You can sue for your profits, your lost profits that you would have obtained if they hadn't been in the market. You can obtain what's called an injunction, which is basically an order not to do something. The judge says you can no longer make this product. That happened a long time ago with Polaroid v. Kodak, which was a huge lawsuit. Polaroid was kind of like the instant photography company when cameras were chemically based, and they had that for a long time. Then Kodak came along and basically said, "Oh, gee, we should make instant cameras too." And Polaroid was not happy about that at all, and there was a huge litigation over it. Kodak lost, and they had to stop making their version of instant photography cameras. So these are some of the disadvantages of obtaining a patent, a lot of which we've touched on already. It takes a significant amount of time to do, usually from a company's most valuable people, because they're the ones that are coming up with these great ideas. So you need to take away time. They need to take away time from their current business activities, and they're pushing the company forward. There are no enforceable rights until a patent is issued, which typically is 3 to 5 years from filing, so it could be a while before you'll be able to enforce it. Although there are options, there is an option, new option, by which you can pay an extra fee and you can get an enforceable patent realistically within 1 to 2 years. But that's about the fastest. And then they're limited in time, unlike a trade secret, which has no hard time period on it. Basically, patent right will always end 20 years, the latest would be 20 years from the earliest filing date of the patent. And that is basically shortened by the amount of time it takes for it to emerge from the patent office. So since it's typically, it's going to be 1 to 5 years to obtain a patent for it to emerge, so if you just do the subtraction, you're talking about 15 to 19 years of actual enforceable time. And we've talked about this already, the deep pockets problem. You know, patent litigation can easily run in the $3 to $5 million range. You know, is there somebody there who will, who can cover that, and does the market justify it? So that's, so now I've basically covered the basics of IP and of patents, and now I'm gonna focus on one particular area of patent law that is particularly important, and it's very complicated and hard to understand. But basically, before I go into all this detail, let me just give you the sort of the 10,000-foot view, which is probably all you'll need, and that is that the grace period. We're going to talk about the grace period, and so basically, a grace period is about your own actions barring your right to obtain a patent on your own invention. In most patent applications, most patent situations, you are your own worst enemy, believe it or not. And if you can get over the hurdle of shooting yourself in the foot, you're probably in pretty good shape. So that's why the grace period is so important, basically. It gives you protection against that. And it basically says that if you take certain steps with your invention that would otherwise remove your ability to obtain patent in general case, the grace period will kick in and say, that's okay for a certain amount of time. You know, if you get your patent on file within a certain amount of time, you're still okay. And so these are called patent barring events. And these are things that you will typically do, particularly as university researchers. Probably the most common is publication of your ideas and other non-confidential disclosures. Well, that's what you're going to do as, you know, as a researcher in university. Now, in basically all the world except the United States, as soon as you do that, you lose your foreign rights, your non-US patent rights. So that's, you know, that's pretty scary. Now it has been until March of 2013, it was the case in the US. The US was the only place where you could publish, but you would still have a year to get your patent application on file. So you had a 1-year grace period. Unfortunately, for inventions that have a filing date of March 16th, 2013 or later, that old rule has been significantly weakened, and it's you know, it's still there to a certain extent, but it's not as clear cut as by any means as it was before. And I'm going to try to explain some of the protections and lack of protection that the new rule gives, because it's complicated. Other patent barring events could be, you know, just publicly using the invention, offering the invention for sale, and there can be filing of a patent application by somebody else. They can sort of beat you to it. So as I mentioned, there's something called the America Invents Act, AIA, which was enacted in September 2011. The part of it that I'm talking about in terms of the changing the grace period, that didn't come into effect until March of 2013. So there were two earlier phases of it which came into effect earlier, but that was the biggest change, and that's why they delayed that the most. The first phase came came within a year of this date. The second phase came within 2 years, and then 6 months after that, the change in the grace period came. And this change was portrayed as, we're modernizing the U.S. patent system, and we're going to achieve greater harmonization with the rest of the world, and so that's what was said. It's extremely debatable. Do we need to modernize our Constitution? I don't know. We haven't really modernized it very much. And let's not forget that the U.S. is pretty much unique in the world in terms of, real first-class inventors are some of the founders. Everyone knows about Jefferson and Franklin, so they really understood the invention process, and they took pains to, actually that's why patents and IP rights are in the Constitution. They knew it was important, they wanted it, and so, really, for a long time the U.S. said, well, really the rest of the world, if anything, they should change to be what we are, and there was that tension for a long time. But unfortunately, I think we've moved towards the road of being more like the rest of the world, which is what they would call an absolute novelty, which means that basically there's no grace period. As soon as you non-confidentially disclose your invention, you lose your patent rights. So, okay. So, yeah, so basically, just to sort of, jump to the chase here. So, although, publishing your paper doesn't necessarily immediately eliminate your patent rights, you're taking an awfully big risk. So, really, you should really operate now as if we're already under an absolute novelty regime. So basically, you should keep everything secret until you have on file an actual patent application that has everything that you think you might wish to obtain. That's basically now. And the grace period that we have left is, you would do that by accident. For example, if you publish it by accident, or maybe there's some sort of a mix-up in terms of dates, but it's there, and it could definitely help you as opposed to the rest of the world. So, let's see. Let's see. So, basically the idea of the grace period was that just because you have a great idea does not mean that you can immediately fully describe the idea and an example of it. And as you well know, there is often a considerable gulf between initially having a potential solution to a problem that you think will be good and that will work, and then producing a proof of concept prototype and being able to experiment with the basic idea and perfect it. And then to prepare a narrative description of it and file it, which is a patent application. Those things all take a lot of time, and that's what the grace period is intended to protect. And also, it gives you time to, particularly for startup companies, it gives you time to shop your idea around and raise capital. So basically, you could, under the old rules, you could go speak to a VC, and basically, VCs in general will not sign confidentiality agreements. So they can, regardless of whether your meeting in itself is non-confidential disclosure, they can disclose it if they want to, because they're under no duty, and that's the way the industry works. So this would give you a chance to raise capital. At least it would give you a year, a very solid year, at least in terms of your U.S. rights. But as I say, that's been weakened a lot. So basically, before you start talking to VCs and trying to raise capital and talk about your idea, you'd better keep it secret and get your patent application on file. Then you have the problem, well, how do I even pay for an attorney to do the patent, to write the patent application? So the problem is that basically what it does is, you know, for inventors that are at the low end of the capital spectrum, that have it really makes it very difficult for them to access the patent system. And that's been well documented statistically, and so there's anyway, there's a lot more that I could go into here, but I think we've been about an hour, about 50 minutes, I think. So I think what would you like to do, Bill?
I'd like to thank you. Questions?
So in your talk here, you put a lot of emphasis of the value of a patent coming from the ability to litigate. So I'm interested in your perspective on, and maybe it's changed over the years, but on the impact of the words patented or even patent pending on the marketability of a given widget that you might see on like a late night infomercial or something.
Well, I mean, it definitely can help. I mean, you shouldn't mark something as patented if it really isn't, and in fact, you shouldn't tout something as being patented if you know that your patent really isn't valid. Maybe you found some killer prior art after you got the patent, but assuming the patent is valid and you think it's valid, yeah, it can be, definitely, and it can be very helpful. It almost always is very helpful in terms of raising capital. So, if you're able to somehow make the investment of filing those initial patent applications, it will make it easier with VCs, for example. Yes, please.
What protections does a U.S. patent offer against infringement overseas?
Okay, well, basically patents are territorial, so a U.S. patent only applies under U.S. Territories, and European patent rights only apply in the EU, European Union, and so forth. And in fact, even within Europe, you still have to actually they have unified patent office. Then you have to pay to obtain the actual patent in each country. Still, they're working on unifying it. So in terms of the most you can do in terms of the U.S. is your interface with the world. So you can block imports, with a U.S. patent from being imported into the U.S. And the U.S. has done a lot in that area. There's a special court called the International Trade Commission, which is just for these types of import suits, and they're very fast and very good at that.
All right, one more then. Let's go on.
Okay, so we all work in college and publish and everything, and there's that neat grace period. But I assume that, so this is probably different for public and private colleges. Well, at a public college, so how does that affect the college getting all the IP of everything they develop, for example? I would assume so. But then what would they do with it since they're a public college, not a private entity?
Well, whether you're a public university or not, you can still keep your information secret, and it's just that you can't really rely on that grace period anymore. You've got to have your patents on file before you publish, because basically what will happen is the new grace period says that for a year after you publish, your own publication can't be used against a later filed patent application. So that's really good. The problem is that, as you know, once you publish your paper, the idea is that it's going to be read by lots of other people, and they're going to, in a sense, republish. They may republish that idea, and they may republish it without attributing you as the source of it. They may think of obvious variations on the idea, and all those things, then you have to then, if those are cited against you in the patent office, you have to knock down each one of those republications. You have to show that either they got the idea from you, which may be impossible, because that's the nature of releasing things publicly. Other companies that you have no control over, they're going to read it and they're going to republish it, and you can't get access to their records to prove it. Well, then you're out of luck. Even if you can you, if they republish an obvious variation of it, the obvious variation can be used against you as prior art. And what exactly that means, nobody even knows, because it's a totally new creation. What they've done is they've added a totally new creation that has never existed anywhere in the world, including the U.S., and it's probably going to take at least a decade to be sorted out in the courts. Nobody really knows what it means. Whereas at least under our previous laws, we had spent about 150 years of litigation figuring out what our previous laws meant.
By you, did you mean the individual or the university representing the individual?
Both. I mean, you still have confidential information. It doesn't matter whether it's a public or private university.
Yeah. So that question is a great segue into a quick introduction that I want to do. We have two local experts from OSU, from our contracting office here. Can you just briefly introduce yourself, guys?
Go ahead.
Sure. My name is Dave Dixon. I'm an intellectual property and licensing manager. I work in the Office for Commercialization and Corporate Development. I work primarily with College of Engineering, and I'm a registered patent agent as well. Not an IP attorney, just an agent. I can explain what the difference is if you care to know. But if you have any IP questions, I would be your first point of contact.
My name's Kurt Fuller. I work with Dave. I'm a contract manager in the same office, and what I do is I contract, consign, and negotiate agreements with industry, and a lot of times they involve research. But in my case, it's when the university is actually responsible for whatever obligations you have with that company. And if you're employees of OSU, then a lot of times you'd be acting on behalf of the university. So I work with Dave closely, and we engage different private entities in different types of activities.
Right. Fantastic. So these guys are some of your first contacts here for this kind of stuff, probably through your advisor. But with that, thanks for coming. Right, we'll do the usual student Q&A here, and then afterwards, I'll come and collect you.
Okay.
I apologize about the heat.